All right. Court of Appeal 1146 District of the State of Florida is now Carrie Ann Wozniak, judge presiding. All persons having been before the court of trial here to defend you will be heard. May God save the United States of America, the state of Florida, and the honorable court. Please be seated.
Good morning, everyone, and welcome to an oral argument session of the 6th District Court of Appeal. I'm Carrie Ann Wozniak, and I am joined with Joshua Mize and Petra Brownlee for her first oral argument with us today. We have 3 cases on the docket. We are live streaming on YouTube right now, so if everyone could please silence your phones, thank you. And we will go ahead and get started with the first case. 23-1244. Todd Copeland Esquire as guardian ad litem for JC versus Osceola Regional Hospital.
Good morning. May it please the court, Kara Link on behalf of the appellants, the Calzadas.
And would you like, how much would you like for rebuttal?
2 minutes, Your Honor. Thank
2
you.
minutes, okay.
This court should reverse the summary judgment below because the trial judge wholly ignored critical summary judgment evidence in the form of the deposition of Kimberly Shantz. Briefly, this is a medical negligence case. My client's son is now 11 years old. He was born in 2012 and delivered, and medical negligence is the theory of the lawsuit. He has cerebral palsy and permanent brain damage. The count against HCA Inc. is for vicarious liability or non-delegable duty for responsibility of the employees, the doctors, the nurses. To be clear, that legal theory has not been challenged and is not on appeal. It's the Pius decision out of the 2nd DCA. The issue before this court is the owned and operated language that is found in Kimberly Shantz's deposition. What this court will not find in the 11-page, let me make sure I get it right, 11-page summary judgment order, 0 reference to Kimberly Shantz's deposition, her errata sheet, her affidavit, or her second deposition.
But that was raised in the motion for rehearing, correct? And that was
Absolutely.
denied.
Yes, Your Honor, it was. And in the order denying the motion for rehearing, there is just a simple denial. At the
Counsel,
summary.
I thought you were, I took your point about the original testimony versus the errata sheet. The problem is her original testimony referred to HCA, and I thought the other side made a decent point in their brief that, you know, there's a lot of mixing of these entities, and when she, you know, under the new summary judgment rule, once they meet their burden, the burden shifts to you, right? So
Correct.
you've got the burden once they meet the initial burden.
That's correct.
And one of the things I think they pointed out was that there's a lot of references to HCA, but there's a lot of different HCA entities, and it's your burden to establish a genuine dispute as to HCA Inc. And I went and looked at that original testimony, and she doesn't say HCA Inc. So they were said, did HCA own a hospital? But there's no entity called HCA. You can't have an entity called HCA, right? They have to have by law some type of, you know,
Nomenclature.
yeah, nomenclature in their name indicating the type of entity. And her question did not.
Thank you for that question, Your Honor. It is a valid one. When you go to her errata sheet, it says she knows exactly what that question was in her deposition, because in the errata sheet, she says, yes, I understand that according to ACA, Osceola Regional Medical Center, Inc., an affiliate of HCA Inc., owns and operates the medical center, the hospital. She uses HCA Inc.
Okay, but she says an affiliate of HCA Inc. So an affiliate of HCA Inc. can be a subordinate corporation, and parent corporation, that's the whole point.
Right.
Under corporate law, parent corporations aren't liable, you
They're
know,
not.
as a general matter for the acts of their subsidiaries.
Right.
So now you rely, your brief said, I'm relying on the original testimony. I've asked you about that.
Right.
What you've said is, well, look to something else. Look
Nope.
to the errata sheet. That seems to be a concession that the original testimony didn't do it. And the errata sheet says an affiliate of HCA, which that doesn't get you where you need to go.
I guess I must have miscommunicated. I am relying and not stepping away from the original deposition testimony. And I recognize it doesn't
Okay.
say Inc. I
Okay.
recognize that. I recognize.
So how does it create, all right, so how does it create a genuine dispute of fact then? If you've got you need to show us testimony that points to HCA Inc.
Right.
You've pointed to that, her original testimony.
Right.
It does not do what you said it did.
And the appellee's argument is that HCA in her deposition is broad. My pointing to the errata sheet merely says she knew that we were talking about HCA Inc. Otherwise, the errata sheet wouldn't have HCA Inc. reference anywhere in it.
Counsel,
It would have said
counsel, that
something
seems,
different.
that's just completely wrong.
Okay.
So,
Right.
so she said HCA in her original testimony.
Yes.
And the whole point of an errata sheet is to clarify things. And she said this entity, what is it, Orange County Regional Medical
Medical
Center,
Center.
an affiliate of HCA Inc., which explains why she referred to HCA without giving any indication that HCA Inc. should be liable. You have to deal with these corporate law issues.
Absolutely.
And your brief seems to be, well, look, there's a big pile of documents with HCA a lot in them.
Right.
There must be a genuine dispute in here somewhere.
There is, if I could, Your Honor, the sole document that made her change her testimony is this state of Florida certificate license from ACA. That's it. One sheet of paper. She says counsel for the hospital medical center, who she's the corporate rep testifying on behalf of, handed her this, delivered it to her in some fashion. We don't know how. And this is what caused her to change her testimony. She says it's a clarification, but when you look at this, it has nothing on it about ownership. It says that the hospital Inc., that Osceola Regional Hospital Inc. is authorized to operate the medical center.
But counsel, they put forward the corporate entity structure. Okay, so that means what you're basically saying is, I don't think this document their burden. The burden has shifted. The burden is on you. So you've got to point to something that shows HCA Inc. owns or operates this hospital. So you keep pointing to things like, listen, they didn't show this. You've got to show it. Once they establish the corporate structure, right, which they did, the burden shifts. Where's the HCA Inc. Where's the evidence that HCA Inc. owned or operated this hospital?
I guess the problem really is the fact that the trial judge didn't say what you're saying right now. Trial judge said nothing about Chance. There is zero reference to Chance in the 11-page order, despite the fact that it was a focal point at the hearing. There was a motion for reconsideration.
So doesn't that show that the trial judge considered it? And so perhaps she thought of it the way that Judge Mize is thinking of it. Okay, this is a clarification because the initial testimony was HCA. And then once the errata sheet is done, there's further clarification and it's more nuanced, so to speak. It's more specific.
But that's weighing the testimony. An errata sheet that clarifies is admissible, like the deposition is admissible. We're relying on the Motel 6 versus Dowling case.
Counsel, the
And
deposition doesn't do what you need it to do, right? Before you get to the problem of whether a trial judge weighed testimony, we have to determine, did you even raise your burden to give the trial judge something to evaluate? Stop skipping that step.
I understand.
Where's the HCA Inc. owned or operated? Give me a record number. Give me something. Give me an exhibit number. I need something that says HCA Inc. owned or operated this hospital. Where is it?
It is that sentence or two in her deposition, and it doesn't have the ink, Your Honor. I'm candid with the court. It doesn't have ink. She said, she is asked, does HCA own and operate? Now, what is important, which is missed, and we cite it in our reply brief, she was asked to bring with her to the deposition documents that relate to the relationship of any of the defendants in the case. That's at record site 2258. She was asked to bring those documents. So the point that is made, 2 points are made by my opponent. The ink that's missing in the deposition, which I understand is concerning to Your Honor, Judge Mize, and the fact of the corporate rep B6 scope of inquiry. They make the argument. So my response is, one, she was told to bring depositions with her that relate to the relationship among the various entities that are defendants. HCA Inc. is a defendant, and Carriage Hills, the only case in our DCAs reported on corporate rep testimony and B6 testimony is right on point. In Carriage Hills, Judge Hansman wrote in that opinion, you don't strike this inconsistency. The jury gets to hear it. The jury gets, it was an improperly noticed B6 deposition.
And I guess that presupposes there's the inconsistency. And I think the problem is if you start with broad testimony, I think our question pertains to if you start with the broad testimony and then you get to the errata sheet, which is more specific. Do we truly have inconsistent testimony that then the trial judge would say, okay, I don't believe them in this instance. I think that I believe them more in that instance. It just looks like she's doing that less, if indeed it starts broad and then just gets specific with the clarification.
The problem we have, and the reason that I do weave in and have to address not only the errata sheet, but she has an affidavit, she has a second deposition, that's all relevant and all admissible for a trier of fact.
Counsel, which one of those things says HCA Inc. owned or operated the hospital?
The
Those are the
original,
only ones that matter.
right,
Which one of those things said HCA Inc. owned or operated this hospital?
her original testimony says HCA
Does anything else
owns
say
or
that?
operates.
Does anything else say that?
With regard to Ms. Shantz?
Yeah, because that's the
No.
burden you've got to meet,
No,
right?
with-
So you,
with
because you said
regard
there's
to
all
Ms.
these different
Shantz.
pieces,
But
but none of
the-
the pieces you cited have the information you need to win.
Right. The errata sheet, Your Honor, if her testimony had not been HCA Inc. owns and operates, and I get it, it's a poorly worded question. Counsel, when we're asking questions in deposition, we don't do it with the best of specificity. However,
Well, sometimes they do.
sometimes they do.
And if they don't, sometimes they lose summary judgment.
Very true. However, in this case, her errata sheet didn't have to say HCA Inc. She could have said, I never said HCA Inc. The question was never asked. That's not my testimony. I have no idea. I'm just this IT person. What's odd and curious about her deposition testimony is she's not even clear. In the two depositions that she gives, the first one, she says she works for HCA Healthcare, North Florida Division IT Group, record site 1676. Her second deposition, she testifies she works for another HCA entity. This time it's ITNS Field Ops Inc., 1785 of the record. She did no independent research before the errata sheet, no independent research before her affidavit. The Attorney Nelson gave her the ACA document, and it's the sole basis for her changed testimony. And that ACA document does not pertain to ownership, maintenance.
Is ownership the true crux of it, or is operation and maintenance the true crux of it? And I would refer you to page 699 of the record when I ask you that question.
I don't know what 699 is, but I'm guessing it's the prior order stipulation. Thank you for the question. So it's probably clear as mud. What I can tell Your Honor is that it appeared the parties at that motion to dismiss stage stipulated that ownership would be out. They were talking about parent corporate
And
liability.
there's a distinction between the entity that owns the hospital and an entity that owns the entity that owns the hospital, because there's a corporate shield.
Correct.
When there's an entity between you, there's a corporate shield, right?
And
So
that's correct. And there was no piercing of that veil. that
you
corporate
don't,
veil.
it doesn't sound like, I mean, the issue here you're trying to establish is that HCA Inc. either owns directly
Mhm.
or
Or
operates.
or
the hospital.
maintains. Correct. Well,
Cor-
yes,
Correct.
that's right.
You agree that them owning an entity that owns the hospital would, on its own, wouldn't be enough,
It's
correct?
removed. That's correct. So to answer your question, Your Honor, it was stipulated ownership was out. It appears that it was in the context of the parent liability context, because HCA Inc., when they moved for summary judgment, plead that they don't own the hospital. I mean, that was in their motion. It's in the argument before the court. So ownership came back in through this second go round or third go round, or however many go rounds it was with the summary judgment that's before this court. Judge Mize, I understand your concern about the general question in the deposition, but that's it. That's it. It's HCA, own or operate. And if she didn't think that it was HCA Inc., she wouldn't have answered her errata sheet. She wouldn't have filed it the way she did. Words matter. And she could have said something totally different. You didn't ask about Inc. She actually answers the question of what HCA Inc. is and where it exists in this context. What's
Because I ask you how this came up. And the reason I'm wondering is, you've got an entity to sue. Why was so much litigation conducted over trying to bring in this other entity? I'm just curious, was the entity that actually owned the hospital uncollectible? Like what? That would seem to be it would seem to be odd to me that this would come up, because
Right.
there is an entity to sue,
right.
and presumably the entity that actually owns the hospital is not bankrupt. I mean, what was the reason so much litigation was conducted over this?
But I don't have an answer that's in the record directly to answer you, other than at page 1065 of the record, I'd refer Your Honor to the SEC 10K report. And it does discuss how the HCA Holdings, Inc., which is the parent company of HCA Inc. We uses the word we, and that definition has been exhaustively discussed in the briefs. We're subject to litigation relating to our business practice, legal actions by patients alleging malpractice. If payments for claims exceed actuarially determined estimates are not covered by insurance or reinsurance, if any, fail to meet their obligations, our results of operations and financial position could be adversely affected. There's more in the SEC report talking about they rise and fall by the hospitals, by how much they bleed, how much they pull in and money. So that's the best I can give you to answer your question that's in the record, because I wondered it myself. The problem with the summary judgment order and the reason why it must be reversed is that paragraph 17 says there is no evidence before the court, no evidence that HCA operated and or maintained, but that's not correct in light of Chance's deposition testimony.
Counsel,
that would-
before you,
Go ahead.
before you get into your rebuttal time, can you address HCA's argument that Ms. Shantz was not noticed for this particular subject area for her deposition and how that affects things?
Yes, 2 points. Carriage Hill's case out of the 4th DCA. Even an improperly noticed corporate rep deposition, and this one was binding with regard to Osceola Regional Medical Center or the Hospital Inc. DBA, the fictitious name Medical Center. It was properly noticed and it is sworn testimony under oath. It may not be binding on HCA Inc. She wasn't appearing on behalf of that corporation, but it comes in to the trier of fact. It is sworn testimony that can't be ignored. This is not a 90.403. We're not sitting at trial and deciding what should and should not go before the jury. This is sworn admissible relevant material deposition testimony. And Judge Mize, you recently authored a 60 CA
Must have been
opinion.
brilliant then.
It was really good on summary judgment reversal and the standards and how they mirror the directed verdict standard. The Benson versus privileged underwriters, it identifies each and every tenet of this summary judgment federal standard. And the one that was missed below was that the court must view the evidence and draw all factual inferences in the light most favorable to the non-movement and resolve any reasonable doubts in the non-movement's favor. The 11th Circuit Court of Appeals in the Feliciano case says that one material fact can be created solely by testimony of a party. This was a party. Under the Carriage Hills case, her deposition is binding on that entity for which she testified. However, it's admissible, relevant material testimony in the case because the Ducis Tecum to her depo gave her notice that she was being asked about the relationships among the various entities. It doesn't bind HCA Inc., but it's relevant material testimony before a trier of fact. I ask that you reverse and remand. Thank you.
Good morning, Your Honors.
Morning.
Morning.
Chance Lyman on behalf of HCA Inc., the specific HCA entity that was the summary judgment movement in this case. Judge Mize, I think you hit the nail on the head. There's not a single piece of competent substantial evidence anywhere in this record that says HCA Inc. owns, operates, or maintains anything, and certainly any hospital. Ownership is off the table. They've conceded that they're no longer going to proceed with that theory at motion to dismiss. That's referenced in our summary judgment motion. That's referenced in the summary judgment order. There's no law that says the trial court had to address Ms. Shantz's testimony. We specifically pointed out in the answer brief that counsel has not raised an argument that that was like a failure to comply with the summary judgment rule, requiring the trial court to state its reasoning on the record.
No, but surely if something did give rise to a just disputed issue of fact, she couldn't ignore that and then grant summary judgment.
Absolutely. If that were the case, absolutely. And of course, that's not the case here. Ms. Shantz never said that HCA Inc. Owns, operates, or maintains anything. And of course, if she did say anything about ownership, that's been conceded that they can no longer proceed on that theory. There are just a few other points I'll make. The notion that the,
Counsel, let me ask you this, if say this testimony had happened at a trial and not a deposition. So. Witness gets up and says, oh, HCA owns or operates this hospital, doesn't say which HCA entity. Lawyers at trial, aren't as precise as they could be, nobody ever clarifies it. If a jury went back to the deliberation room, they'd have to try to figure out what HCA meant was, wouldn't they? They'd have to try to glean some meaning from that testimony. wouldn't they?
well, if it was allowed to go to the jury, that might be the case, but I would say that's the situation you just described would be directed verdict territory. Because there's no competent substantial evidence from any witness that HCA Inc. owns or operates anything. If the person just said HCA, I mean, that's just not evidence of HCA Inc. doing anything. So, if that were to go past directed verdict, it might be an issue on appeal. The notion that the Ducis Tecum aspect of the deposition notice changes anything about her testimony or her representative status is just wrong. The specific line that's been highlighted in the reply brief actually refers to you, meaning Ms. Shantz's relationship with any of these entities. I think she testifies adequately what her relationship was. She certainly didn't bring any documents that show HCA Inc. owns or operates anything. And Carriage Hills certainly tells us that you don't get to modify your corporate deposition topics by the use of the Ducis Tecum document. And in fact, I just have to disagree with counsel that Carriage Hills supports the appellant's case here. It very clearly, I think, says if you do not conduct the deposition pursuant to the notice that you gave, you did not obtain corporate representative testimony. Of course, that really isn't material because Ms. Shantz never said anything about HCA Inc.'s ownership, operation, or maintenance of a hospital. Regarding the pointed questions that could have been asked at Ms. Shantz's deposition, she was there to testify about audit trails. In about the first 5 or 10 minutes of the deposition, she is asked whether HCA owns and operates a hospital. That's patently outside the scope of her deposition notice. And really what it does is it ignores the fact that HCA Inc. already presented a corporate representative who testified exactly about that topic.
Counsel, does that mean the testimony is inadmissible, or does that just mean it just doesn't bind HCA?
The latter, Your Honor. It doesn't mean it's inadmissible.
Yeah, so like, for purposes of summary judgment, doesn't matter if it binds HCA, you just need testimony from anybody, don't you?
Well, I would say yes, Your Honor. I'll say yes.
So is the point you're making not relevant to your argument?
Well, I just wanted to point out that there was a corporate representative from HCA Inc. who did offer unequivocal testimony about the structure.
Okay.
But so if that comes in, right, if that evidence comes in that she said HCA owns it. Now, granted, say we take your argument, right, and we say then that doesn't bind anyone, either of the two entities, right? Certainly not HCA because she wasn't appearing as their corporate rep. But if that's still in the record, does it then create that disputed issue of fact? Or if it did go to the jury, does that constitute weighing the credibility of the witnesses? Well, she did say HCA, but then she takes the time and corrects herself and is more specific. I mean, wouldn't that be weighing the testimony?
So I will say the hypothetical where Ms. Shantz ever said HCA Inc. does anything. I just want to make sure we're in that hypothetical world because that did not happen in this case. The notion that the errata sheet modified her prior testimony such that she was talking about HCA Inc. I don't think that can be supported under the record since, as Judge Mize pointed out, the errata sheet says HCA Inc., an affiliate, owns the hospital. Now, if hypothetically Ms. Shantz, as a lay person, said HCA Inc. owns and operates the
Say
hospital.
she doesn't say HCA, say the testimony is as it was in the depo initially. So she would be saying at trial before the jury, HCA owns the hospital.
Without the Inc., I would say.
Without the ink, but then subsequently, just like the errata sheet, say it's on redirect or something like that, she then says, she clarifies and says who exactly owns the hospital and how it's laid out, right? Then if that went to the jury, if you lost on directed verdict and that went to the jury, isn't that weighing the credibility of the witnesses if the jury is sitting around and discussing that specific testimony?
And keep in mind that lawyer who can go to closing and say, she was lying the second time, they tripped her up, right? She was telling the truth the first time. She got nervous. She realized she gave an admission and she lied to you the second time. Believe her the first time. Go back there and give us a verdict.
So that to me, it sounds like the same question earlier about whether, if HCA Inc., if she said HCA Inc. the second time only, That would just mean that there's no testimony that exists in the record anywhere that HCA Inc. owns or operates. So I think the note, so that would be a directed verdict, I think. If the jury were allowed to consider whether a changed answer that adds the context that previously the deponent said HCA and nothing else, and then later the deponent said, just to be clear, an HCA Inc. affiliate owns and operates this hospital. There would be no credibility to weigh because there's no dispute in that testimony, I think is the answer to that question. Of course, I would just say, honestly, under the new summary judgment standard, a lay person who is not noticed for that topic, who comes to the deposition and says, HCA Inc. owns and operates a hospital in response to those two questions, I would submit that that's really not a reasonable juror could not find that HCA Inc. owned, operated, certainly not owned because they've conceded they can't do that, but operated or maintained the hospital. I don't think I have to make that argument because that testimony doesn't exist, but the summary judgment standard requires them to do more than just allege that a credibility issue is in play just because testimony exists. They have to present evidence that shows that actually disputes credibility. And that's really what the summary judgment rule requires. Just Judge Mize, the notion, why do they even want HCA Inc. in this case? I mean, I can only assume that the plaintiff believes there's a strategic benefit to that, but I can assure you that this is not a finger pointing situation. I think the summary judgment order makes that pretty clear. The actual ownership, operation, and maintenance entity has answered that it does own, operate, and maintain the hospital. So there's certainly no issue there.
In other words, they've got somebody to sue.
Yes, Your Honor. At the end of the day, I think this is just a case where there's just nothing there. That's as simple as that. And I think Your Honors know that our position is that this is essentially a frivolous appeal. There's nothing in this record that shows that HCA Inc. owns, operates, or maintains any hospital. The trial court was eminently correct in granting summary judgment. If there are no further questions, I'll yield the remainder of my time.
Thank you.
I hate to start off on it, but this is not a frivolous appeal, and I do take umbrage with that argument. Defendant cites no law that a deposition, that sworn testimony can be ignored, that it simply disappears. Ms. Shantz is a somebody. She works for an HCA entity, although she's changed it under two depositions, what entity that is. She was there. What happened at the hearing, the trial judge asked both sides and understood plaintiff's argument. And I'm sorry, I don't have the record cited. It's page 29 of that hearing transcript. And she said, so did I understand you? Both the depo and the errata sheet are evidence for purposes of today's summary judgment hearing. That innately contains a contradiction that would preclude entry of summary judgment. She gets it. Yes, Your Honor. She says to Appellee's counsel, then what say you? And the argument is, well, if I said I graduated from law school in 1985, but it was really 95, I misspoke. I can use the errata sheet to correct it. And that doesn't mean that my initial answer is still there. He argued the initial answer disappears, but that's not the law. That's sworn testimony. Doesn't matter if it's from a corporate rep of one of the defendants or an employee of the hospital. It's sworn deposition testimony. It doesn't disappear. There's no case that supports that, but that's the best that we can glean from the trial record of where the judge went and why Shantz, the word Shantz, doesn't appear in the 11-page summary judgment order. Nowhere. There's no explanation of the rejection of the testimony, the affidavit, the sworn errata sheet, and the second deposition. And I will leave with Carriage Hills. Carriage Hills absolutely says, even if the notice is deficient, that the trier of fact will be able to consider the testimony. Carriage Hills may or may not be bound as a witness, but it's subject to cross-examination. And Judge Mize, just what you said, you get to tell the jury, get to ask the witness on the stand. They get to ask the witness on the stand. Now, you testified you worked for two entities of HCA. Which one is it? You don't work for HCA Inc. You don't know anything about HCA Inc. Counsel gave you a piece of paper that said ACA understands. They gave an operational license to Osceola Regional Hospital, Inc. to operate the medical center. That's what goes before the jury, and the jury goes, okay, HCA Inc.'s not liable. But that's not what happened here, and this is not the way summary judgment, even under the new standard, should operate. We ask that you reverse and remand. Thank you.
Thank you.
Sorry.
Do you need a break? Okay, thank you, counsel. We will move on to the next case on our docket, which is 23-549 Environmental Research and Education Foundation, Inc. versus City of Naples. And take your time getting set up. I didn't mean to rush you. Counsel, how much rebuttal time would you like?
10 minutes, please.
10 minutes?
Yeah.
Okay.
Good morning, Your Honor, and may it please the court. My name is Laura Olympio. With me is Doug Manson from the law firm of Manson, Bolus, Donaldson and Tanner. I represent Appellant Environmental Research and Education Foundation. This appeal presents the court with an important issue about who's ultimately responsible for the regulation of fertilizer in Florida, the state or local government. The relevant facts in this case are brief and mostly stipulated. The city adopted an ordinance regulating fertilizer in 2008. They then amended that ordinance in 2017. In 2018, Southwest Florida experienced blue-green algae and a red tide. Following that event in 2019, the city voluntarily enacted the ordinance that issue.
Council, we read the facts.
Okay.
I didn't see much discussion in the brief of the interplay between 576-181 and 403-9337. And here's what I mean by that. I think your preemption argument on 576-181, I thought made some good points. If you're regulating the formulation of fertilizer, if you say you can't use a fertilizer with this formulation, that seems to be pretty clearly pretty clear a regulation of the formulation of fertilizer. Problem is, you get to 403-9337 and it seems to explicitly authorize this. Now, I take it you do not think 403-9337 authorizes it, but assume that it does. How do we, if we agree with you on 576-181, but disagree with you on 403-9337, how do we harmonize those two statutes where we have one preempting regulation of a certain thing,
Mhm.
and we have one purporting to authorize regulation of a certain thing?
So to address that harmony between the state and local government, it's clearly envisioned within the large balance that we're dealing with when it comes to larger fertilizer regulation and how we ultimately got here to the two statutes at issue today. I'm going to be a little long-winded here, so forgive me. But in 2003, when the legislature recognized that fertilizer could impact water quality and ultimately affect it, they put together a task force at the state level to create what was called a model ordinance. And that model ordinance took many years, and there was a comprehensive effort, science-based, to create, here is what we think the textbook standard should be for fertilizer regulation. That model ordinance is encompassed within 403-9337 and the larger Water and Environmental Protection Act that DEP has within 9335 through 9338. That act in itself does three things. The 9337 sub 1 encourages all local governments to enact that fertilizer.
Council, we know what the statute do. I promise you, we read
Right.
them.
And so,
All right.
go ahead.
Let's say you win on 576-181 and we think you lose on 403-9337. What do we do?
It is upholding the plain language of 9337 sub 2. So the lower court specifically determined that that a water body does not have to be impaired to have more
Council,
specific
But
regulations.
I stipulated that 403-9337, we assume that it authorizes this. Like, you're trying to tell me that 403-9337 doesn't authorize this. So you're fighting the hypothetical.
I'm sorry.
So we think 576-181, for suppose we agree with you, it preempts, says they can't have these ordinances. We think 409-337 does authorize it. We disagree with your argument on that. We decide 403-9337 purports to authorize this statute. They meet the requirements of 1 and 2. What do we do if we decide you went under 576-181 and they went under 403-9337?
I think you have to concede the 576 language. It is expressly preempted to the state.
403-9337 expressly authorizes it.
And the city's ordinance is in conflict with those provisions of one of.
Okay, but now you're
subject
fighting
to-
the hypothetical. You're saying that they don't win under 403-9337. I'm telling you, we might disagree with you,
That they,
okay?
that they.
So don't challenge the hypothetical. Don't try to say they don't win under 403-9337. I know you're arguing that, but I'm asking you, if we disagree with you
Mhm.
and we think they went under 403-9337 and you went under 576-181, what do we do? We have one statute purporting to preempt the field of regulation, right? Which I think you have a good argument on.
Mhm.
And we have one argument purporting to expressly authorize a particular type of statute within that field. What do we do?
I would concede to the wisdom of the court and ultimately say that it might be worth certifying a question of great importance that might need to go to the higher.
Do you think that the
tribunal.
statutes are in conflict? Do you think that the statutes can be harmonized? I mean, we've got
do
the
not.
one level where we've got the preemption issue, right? Where we've got the statute and then we've got the ordinance. We also have these two statutes. And if we're concerned, as I think Judge Mize is articulating that, well, one of the statutes might expressly authorize this ordinance, then is it just a preemption argument, or do we have a problem where the statutes conflict and cannot be harmonized?
EREC would proffer that the harmonization exists, and that's where it goes back to this larger comprehensive.
Sorry, were you saying they can be
They
harmonized?
can be harmonized, yes. And I think that goes into the two sentences with it and the distinction between 403-9337 and those three encouraged, shall, and then the criteria. And ultimately, if you do get to sub 3 of 403-9337, there are 3 recognitions in place within that statute. First, as I touched on, one was encouraged, that they encourage all local governments to enact that model ordinance. Then secondarily, you get into sub 2 of 9337, where there are 2 sentences there. That first sentence says, if the Florida Department of Environmental Protection makes a specific finding that is encompassed within their larger comprehensive regulatory framework, that a water body is impaired, the local governments within those water bodies that are upstream, so impacting that impaired water, shall enact the model ordinance. It then gets to the next sentence, and that's where the lower court made that decision, and ultimately the large reliance on the city of Naples is the may in that second sentence that says, if more stringent regulations are needed, a local government may enact things, and then goes into that A and B criteria.
So I think that's what we're asking
yeah,
is,
and-
isn't it expressly authorized by the may?
So what EREC proffers, and we believe that the harmony exists, is the balance between those two sentences are within the same subsection. It is recognizing the acknowledgement that DEP has to make that determination that a water body is impaired to then get to that secondary regulations. And the reason for that exists because within that comprehensive framework, and it's touched on in amicus and also in our brief, this is a comprehensive program that DEP is enacting. There are multiple steps to get there. The first step is that they have to determine what a water quality standard is. Second, which is where we hit that impairment level, is hey, there is a problem. And once we make that problem for a water body, we determine it. Then we get to those next steps.
But what if
which
you,
is where-
what if you presume the water body was impaired? Let's just change the facts. I know you all dispute that, right? Or you think it's an untimely determination of impairment,
Yeah.
right? But let's take for granted and just say it was impaired. It was impaired before we're going to change, it's going to be a complete hypo. It was impaired before the ordinance was passed, okay?
Sure.
It's a better world for them, right? However, now in that new world, is what they did authorized?
No, because they put the cart before the horse. Just because something is impaired doesn't mean you can then enact more stringent regulations to fix it. We don't know what the problem is yet. And that's where we're still in the second step of DEP's larger comprehensive regulatory program.
But let's assume then, okay, I didn't expect the second portion of it. So let's assume they did everything right under the statute, everything under 403-9337 in order to enact more stringent standards. Let's just say they checked all those boxes. Then could they regulate in the manner in which they have
Yes, but we're not,
and comply with both statutes?
yes, but we're not there yet. That's, and unfortunately, that's the problem. Timing here is the problem, is because, and to.
But
take-
essentially,
take
then
like
you're
a hypothetical-
conceding there's a world in which this isn't preempted. It's not unauthorized.
It is not that it is preempted. It is sitting here today, the city's ordinance specifically under 4039337 moved too quickly. And they are trying to use that more stringent language within.
But Council, if you're
9337.
saying in theory, they could satisfy 4039337.
Yes,
That's
sir.
what you're saying. Like you say they didn't, but they could have if presumably they had, met the requirements of it, which you say they didn't. Isn't that a concession that 576-10181 doesn't preempt? And that the whole case is about, did they comply with 4039337?
To take a step back, no, at a fundamental level, we do believe that this is expressly preempted to the state. But we
Then how
do
can
also,
4039337 authorize what they do?
because ERA proffers that there is harmonization between these two statutes. And here, when it comes to the 4039337 issue, it's truly timing. Water body was deemed impaired. And there are further steps within DEP's comprehensive regulatory process. They have to create a nutrient target goal. What is the cleanup
But
goal?
Council, that's
And then-
the question. You're saying if they did if they satisfied 4039337, that would allow them to authorize, pass these ordinances, and they didn't satisfy it.
Because they
But
move
if
too
there's a
quickly.
world in which they could satisfy it, how do you square that with saying 576-181 preempts it? Because that would seem to presuppose they can't do these
What
things,
ex-
they're
what-
preempted.
And excuse the miscommunication on my part, sir. It is, they can go and enact a more stringent ordinance. The plain language of this ordinance today would not pass muster.
And
therefore it's
Tej-
it's expressly preempted due to formulation.
So it sounds to me like what you're saying is that 576-181 preempts.
Yes.
Okay. But then as part of the regulatory regime that the state has set up pursuant to its preemption authority, it authorized particular ordinances in particular circumstances, provided you comply with 4039337, right? That part of the state's preempted regulatory regime where it occupied the field was to authorize local governments to act in very specific certain circumstances by complying with the requirements of 4039337. But you say they didn't do that.
Correct.
Have I got this right?
Yes,
But they
it-
could have,
but they.
is
could-
what I'm hearing.
Yes, and that's the problem. It's the timing. They acted too quickly. They acted before that target nutrient level is created and that larger comprehensive plan is approved by the department, which the city can participate in that process. So that's the merriment. More stringent regulations can exist because there could be truly circumstances where water body needs more stringent fertilizer regulation.
All right.
Because right now, we don't know if that exists for Naples Bay.
Is that
Council-
true? Go ahead.
I was gonna, that helps me harmonize the statutes. Now I'm looking at 4039337. And the terms in these requirements, you're basically saying, pull these terms from another area and give meaning to these terms. And these seem to be terms that seem very hard for judges to give any meaning to. These seem to be to me, very inherently political discretionary terms as part of a comprehensive program to address nutrient pollution, which is science-based and economically and technically feasible. That seems to me to be the definition of something judges are completely incompetent to review. How am I supposed to decide whether their thing was comprehensive?
No, that's fair, but that is where 403067, which is the department's total maximum daily nutrient program, is this comprehensive scheme. It is encompassed in.
But
statute.
is there anything in the statute that tells me that when 4039337 refers to a comprehensive program, that's the comprehensive program it's referring to?
I would first point you to the language within the first sentence of sub 2 of 90337, which expressively points to 403067 and points to that TMDL comprehensive program that is encompassed in another portion of 403.
Is there sort of a checklist in there then that states what that comprehensive program?
Yes,
A comprehensive program needs A, B, C, and is there some place in your brief where you tell us which of A, B, and C is not present?
I will
here?
say, I do have to concede my unequivocal yes. It is a 12-page, 403067 is a 12-page statute with a lot of criteria that is envisioned within it. And
But your argument in the brief wasn't that wasn't complied with, right?
no. It is just recognizing, and I'm hoping to get to Judge Mize's question, is what is this comprehensive program, the science-based, economic, technically feasible?
We're kind of, it's,
Those,
these are intertwined.
yes, those buzzwords, for lack of a better phrase, are encompassed within 403067, which that is the statutory authorization for the Florida Department of Environmental Protection to enact this larger comprehensive regulatory program that establishes the water quality standards, that implements those impairments, that creates, hey, here's our cleanup goal, and then ultimately through collective efforts through stakeholders and local government establishes, here's the comprehensive cleanup goal that, as Amicus and others have touched on, ultimately is effective for cleaning up those
So
water.
I just want to confirm, just to make sure I understand. So your argument is the second sentence of subpart 2 of 403.9337. A local government may only adopt these additional stringent standards if the local government is listed as impaired in the first sentence?
Yes.
Okay,
so
isn't that adding extra words to the second sentence?
Yeah, it
that
doesn't say
aren't
any such
there?
local government.
it is the merriment between the two sentences within sub 2. Sub 2 recognizes that once a water body is deemed impaired, you shall enact the model ordinance. We believe that the legislature included that rationale to apply to the may and the more comprehensive criteria within the second sentence of 2, and then A and B, recognizing that within this comprehensive process and this cleanup process, there may be more fertilizer regulations that are needed depending on the specific circumstances for that water body.
You're well into your rebuttal time, so.
Yeah, I will say if there are any further questions, I will reserve the rest of my time.
Okay, thank you.
Morning.
Morning.
Good morning.
Hey, police court. My name is Paul Waters. I am with the Bose Law Firm and we represent the city of Naples. We act as the city attorney. And we are asking that the court affirm the lower court's decision and uphold the city of Naples fertilizer ordinance. There are two main issues in this case, as you know, the preemption argument. And also the second issue is whether we complied with 403.9337 in adopting the ordinance. So to get started, the preemption argument, you know, we don't agree that the state is preempted through fertilizer.
That seems to me a really tough argument, counsel. All of these regulations have to do with formula. Right? There's lots of different kinds of fertilizer, right? There's nitrogen based, there's cow manure, right?
That's true.
And it says we exclusively regulate, exclusive authority to regulate, among other things, formula. Okay. And every one of these restrictions, even 52.184A is, you know, blackout periods pertain to fertilizer containing nitrogen. That's a formula-based restriction. And then D, even more so, you know, give specifics as to the amount of, you know, particular ingredients in it. And I get your pointing. You're saying all we say is they can't use it. It's an application. And to me, that just seems to lack any sense at all. I mean, if you say you can use one formula, but not another formula, how is that not a formula-based restriction, right? Like if you're going to restrict based on formula, there's different areas you can do it in. You can say you can't manufacture fertilizer of a certain formula. You could say you couldn't import it. You could say you couldn't sell it. You could say you couldn't apply it of a certain formula. If you're going to restriction, you have to do it at some level of the industry, right?
Yes.
And so if you say, which this ordinance does, you can apply fertilizers of this formula, but not this formula. How on earth can you say that's not a regulation of formula?
Because Your Honor, that's a good question, and I'm going to use Scott's, for example. That's a name we may all know from going to Ace Hardware or Lowe's. Scott's is a company that makes fertilizer. We are not telling Scott's what they have to put in the fertilizer, what the mixture has to be, what has to be on the labels. We're not telling Ace Hardware that they can't sell the fertilizer. We are saying that you can't apply fertilizer.
Counsel, you just okay. If you're going to do a restriction based on formula, you've got to do it at some level of the process.
Yes.
Okay, I'm going to repeat the question. You can do it at manufacture. You could say you can't import a certain formula. You could say you couldn't sell a certain formula. You could say you couldn't apply a certain formula, which is what you do. The point is it's based on formula.
Yes.
You allow other formulas to be applied, right? You don't allow this formula to be applied,
Yes.
okay? the regulation of formula has to happen at some part of the industrial process, right, of the economic process. You chose the application layer. But it is still formula based, is it not? You concede if they were not using one of these formulas, they could apply the fertilizer, right?
Correct.
Okay.
With the nitrogen.
So the ability to apply the formula, the ability to apply the fertilizer under your ordinance is 1,000% based on what the formula is, right?
Not necessarily, there's also time restrictions during. the
Based on
season,
based on what's in it, correct?
But it still only applies to the application.
But council, don't bypass the question.
Sir.
Whether they can apply it depends wholly on what is in it, right?
That is correct.
Okay. If it was a different set of ingredients, a different formula under your ordinance, they could apply it, right?
Correct.
But under your ordinance, because of the formula they're using, they cannot apply it, right?
Correct. If it
Do you
has that
really
nitrogen-
think that's not a formula-based restriction?
Yes, the city of
Okay.
Naples feels that that is not.
I think the city of Naples is delusional.
Why not? What's the city's position on why it's not? How is it not regulating formula?
Because it applies, and I hate to keep going back to this, but it applies to the application. We're only applying to the applicators. We're not telling fertilizer manufacturers that they can't sell this fertilizer in the city of Naples. We're
But what would be I think the problem is, right, what would be the point of selling it? No one can apply it. So aren't you cutting it off at its knees a little bit?
Yeah.
I understand.
Council, imagine an ordinance that applied at the cell level, right? Say you had said, okay, you can sell fertilizer, say you don't sell, instead of saying you can't apply, you had said, you can't sell a fertilizer of this formula, but you can sell a fertilizer of a different formula. Would you have told us that was a regulation of sale and not formula?
That's a tough question. Your
Is it
Honor.
tough because it's indistinguishable from the hypothetical and you have no answer?
No, I do have, I keep going back to my answer of the city's position is the ordinance deals with the application.
Okay,
And the
so
word
say it deals with
application
sale.
Is important.
So say it deals with sale. You can sell one formula, but you can't sell the other formula. You're telling me is that a sale rate restriction or a formula restriction? Or both?
Yeah, but I don't do both.
Okay,
Um,
so the one that says you can apply a certain formula, but not a other formula, is that not both application and formula?
Your Honor, I understand your questioning. This goes back to your question of how do you square up the two statutes? If one conflicts with the other, where do we go? And the answer is, we go to home rule authority, we go to local deference.
But there's local deference unless it conflicts with general law, right? Isn't that home rule?
That is the rule, unless it is preempted or conflict, and our position is, it does not conflict, it is not preempted.
Do you at least concede that subpart D of the statute, I think we were on A before, and 52-184 sub D, that does expressly regulate the formula, the slow release language? I mean, how do you get out of that one?
No, because it's again, our position is 100% application based.
Okay, so tell me in D how it's application. I understand your argument, at least for A,
Which statute are you referring to?
the ordinance, sub D of the ordinance. Why isn't that? I even think the title, I'd have to pull it up.
52-184,
It's
fertilizer
Seventy.
application and urban landscape maintenance.
Sure. I understand that that is a hard section to get around. I understand that. But if you go to 52-183, the applicability section of the ordinance,
Okay.
it clearly says that this applies to the applicators of fertilizer. It's not meant to apply to the content of fertilizer, or the labeling or the packaging of the cell, just the application.
So council, what if it had been the different? What if it had said this applies to the sellers of fertilizer? You can apply any fertilizer you want, you just can't buy it. Would you say that regulates sale and not formula?
Now ask that again, Your Honor.
So what if your ordinance said in one, in section 52-183 said, this applies only to sellers, not manufacturers and not users. You could use it, you just can't buy it. You can use it of a certain formula, but you can't buy it if it's this formula. Would you say that's sale and not formula?
That's sale, not formula.
Okay, so in what way could somebody, it seems like no matter what area of the stack they do it at, whether it's manufacturer, sale, or application, you say that's what it's regulating and not formula.
Yeah.
But if you're gonna regulate formula, you have to do it at some level of the stack, right? You have
Yes.
to, okay.
Yeah.
So which level of the stack would be a formula-based restriction?
That's a tough question to answer, Your
Okay.
Honor.
Is there any way to, under your reading of the statute, is there any regulation of formula that could be a regulation of formula? Can you give me anyone?
No.
Okay.
I don't think we are regulating the formula.
No, but I know that, I know you're arguing that. I'm saying you're, the idea that you're not regulating the formula is based on your idea that it's application, not you, not formula. What I'm saying is you have to regulate the formula somewhere, whether it's at the sale point, manufacture point, or the import point, or at the use point. You've chosen the use point.
Yes.
And I gave you the sale hypothetical, when you said, well, that would be sale, not formula. So no matter what place in the economic process, they're regulating the formula, you tell me it's not the formula, it's the sale or the application.
Yes.
What regulation could they possibly put in place under your reading of the statute that would count as a formula regulation?
That's a tough question to answer. Your Honor.
Okay, so the state regulates, preempts formula regulation,
Yes.
and you're saying there's no ordinance that a local government could possibly enact that would fall in line, that would fall into the preemption. Wouldn't that mean the state's preempting nothing?
Your Honor, we go back to application. That is the key word. We keep falling back on application. And I'm not trying to avoid your question, but I am trying to state the city's position of this is an application statute. And just to kind of drive that home, the last days of session, 2013, the budget implementing bill, the governor, line 2,400 of the governor's implementing bill, he amended 9403-9337. And I have a suspicion it was because of this case, by the way. There are, I think there's around 100 fertilizer ordinances in the state, and this is the only one that's been challenged so far. So I think the budgets, the governor's budgetary language was as a result of this case. The governor actually put the word application in his language. So he saw that the word application is important. The industry saw that application is important, so they added that to the budget implementation language. And if the legislature wanted to regulate application, they would have put the word application in the statute, and they did not. So, moving on to by the way, the appellates in their brief, they failed to cite any cases about preemption. And they only cited cases about preemption in their reply brief, and they were two, and they can be distinguished from this case. The first is the Florida Power and Light versus Seminole County case, and that deals with bearing power lines, and bearing power lines increases the rates.
Sorry to interrupt you, counsel, but there's an issue with the timer. You actually still have 9 minutes left, and I'm keeping track of it on my phone right now.
That's what I saw.
So yeah, you still have 9 minutes. I'll put my hand up when you have 5 minutes left, and then when you have 2 minutes left.
Thank you.
We're not tech savvy.
Yeah, sorry.
That's new.
But in that Florida Power case, counsel, because you brought it up, it doesn't expressly regulate costs, right? Instead, it was, well, it's necessarily that if you know, all the cables have to be put underground, that it's going to increase costs, right? And so thereby it was affecting what it could not affect, right? Isn't that somewhat akin to what's going on here? That if you do touch on formula, if you do touch on formula, but you do so in the context of application, that by virtue of regulating application, you're regulating the formula?
No.
Also, if your sales is preempted too, and if you can't use something, you're not gonna sell any of it. And that seems to be pretty close to the FPL case, right? They said, well, this regulates state preempted rates, and even though this has nothing to do with rates, it's gonna increase costs. Well, if you can't use fertilizer, that's certainly gonna affect whether people buy it.
Sure. Now, the distinction is though, the rates are expressly preempted to the state. Here, the application is not expressly preempted to the state.
But
But they were talking about putting the power lines under. They were
Yes.
talking about rates,
It
right?
increased but by doing so, it increased the rates for
Yeah.
users up and down.
And by
So-
regulating application, you're gonna thereby affect sales. Is somebody gonna buy fertilizer they can't use?
But it's limited only to the jurisdiction within the city. We're not regulating.
So was the city that wanted them to bury the power lines. They weren't saying bury power lines in some other city.
Understood, but
Okay, so tell us how the cases are different.
because of the express preemption of rates. And I understand your argument that if it affects rates all over the state, why doesn't the formulation also affect statewide? This is not the case here. The Florida Power and Light case, or I'm sorry, it's actually Florida Power Corporation. It affects the entire state. This doesn't. This only affects city of Naples. That's it.
Well, hold on. They were only required to bury power lines in the one locality at issue in that case, right?
Yes.
Okay, and rates are, it's not like we have one flat rate for electricity statewide. The rates are approved on a locality basis too, aren't they?
Yes, but it increased rates all around the geographic area or all around the state. This, I don't believe the fertilizer ordinance would increase the cost or the sale of fertilizer in other parts of the state. We're not affecting Miami or Fort Myers or Okeechobee. We're not affecting those places. We're only affecting the city of Naples. That's it. The second case they cited, which is a very recent Supreme Court decision, the Creed v. State, that's a gun law case. And I'm sure your honors have read that case, and that basically said locals, the state.
It's a very different kind of preemption.
The state, gun regulation is preempted to the state 100%. Again, the distinction there is express preemption. Application is not expressly preempted by the statute. So in order to get to express preemption, we think that you would have to go to implied preemption based on the word application not being in the statute. And as you know, the courts frown upon implied preemption, and I've actually cited Sarasota for election versus Browning, that Supreme Court case in my brief. So, it's also important to point out that the city's ordinance, it doesn't frustrate the state's authority. It doesn't necessarily, even if it conflicts, it doesn't frustrate the intent of the legislature, which is to maintain and have clean water in the state of Florida. The governor of the state of Florida just this year, I think, implemented $240 million for clean water. So this is a very important issue, not only to the legislature, but to the governor. Our ordinance doesn't frustrate that purpose. If anything, it helps. So with that, are there any other questions? Yeah, I can see the rest of my time, and thank you very much.
Thank you.
Yeah.
I will be brief. One point just to reiterate, following questioning of council. The Florida Department of Agriculture and Consumer Services is the state agency that is charged with regulating sale, composition, packaging, labeling, wholesale retail distribution, and formulation of fertilizer. Formulation includes content level and release rate. That is expressly preempted at 576.1.5A.
So does that mean that there is no way they could follow a checklist set forth in 403-9337 and have the ordinance be lawful?
Yes, that, and this is the harmony question that I seem to be faced with today. ERAC believes that there is harmony between 576 and 303 in that larger comprehensive process. The Florida Department,
Can you go further into the why we should use the definitions from 403-067, because I'll be honest, when I first looked, I think the preemption argument is strong. I think that's clear. I think it's a very strong argument. When I first looked at 403-9337, though, these seems like the type of terms to me that commit judgment to legislative bodies, right? Comprehensive program, science-based, economically and technically feasible. These seems like terms that say judges have no business trying to figure out whether or not a locality is compliant with this. But you seem to be telling me that, no, there's hard requirements that courts can review in 403-067, and that's what these terms mean. Can you tell me more about why we should tie? Maybe it's just something I missed. Maybe it's really clear, because nothing in 403-9337 subsection 2A says use the definitions from 403-067 for these terms. Can you firm that up for me?
Sure, I'll do my best. So as you touched on, comprehensive program, science-based, economically, technically feasible. Forgive me, but I'm gonna read a little bit of 403-067. Again, it's a 12-page statute, and it explains that multi-step process of identifying water quality standards, problem, goal, cleanup. The legislature finds that while point and non-point sources of pollution have been managed through numerous programs, better coordination among these efforts and additional management measures may be needed in order to achieve the restoration of impaired water bodies. The scientifically based total maximum daily load program is necessary to fairly and equitably allocate pollution loads to both non-point and point sources. Implementation of the allocation shall include consideration of a cost-effective approach coordinated between contributing point and non-point sources of pollution for impaired water bodies and water body segments. So you see, just with that little provision, not apples to apples, but there's a clear recognition and a balance between 403-067 and 403.
Where's the thing that says here's definitions from 403-067 for the terms in 403-9337 sub 2A?
That is what this comprehensive process between DEP, and it's truly an administrative process. That is that comprehensive process, and that's where that
How do we
program
know,
exists.
how do we know that this is the comprehensive process referred to by 403-9337?
As I touched on previously, the first sentence of 403 sub 2 specifically recognizes and points to 403-067.
But that's for,
The shall, and we believe that rationale, the legislature continued that rationale through the may provision within that second sentence. And then the A and B criteria. So the establishing of the cleanup goal and the comprehensive program, that is a collaborative effort that is established in administrative law. And local governments, water management districts, numerous other stakeholders actively participate in that process. And that is the opportunity for the city and DEP through a science-based collective effort to establish, here's what we think that cleanup goal is. And this provision, 2A and B, is the recognition and the belts and suspenders, if you forgive the analogy, that if there is a water body that might need more stringent regulation for specific circumstances, we have an opportunity to do that. There's that specific, there's the model ordinance, and then you go back to 576, which is the express preemption with FDEX, that the fertilizer is regulated by the state. Those statutes can be married. Unfortunately, here with the city, it's timing is the issue.
so there's no issue with regard to formulation versus application. Your issue is the timing and whether it actually satisfied the criteria for more stringent requirements.
Let me clarify.
That's
because-
really important to me because I thought the first portion of your brief was all preemption.
Yes, and the language that is written in the 2019 statute, if I haven't been clear, we believe is expressly preempted.
Which
What we-
statute? 576.181?
I'm sorry,
Well, which statute? You said statute.
we believe that the 2019 ordinance is expressly preempted under 576.181.
Okay, but then you said that these two statutes, I'm holding the statutes here.
Yes.
576.181 and 403.9337 can be read in harmony.
Yes,
The issue here is that Naples did not follow.
they
The
put the
requirements
course and put
of
those
subpart
and-
2.
and put more stringent regulations into early. I apologize
Okay.
for jumping the gun.
No, no.
403-9337 sub 2A says, before it gets into those terms we're talking, so the local government has demonstrated as part of a comprehensive program to address non-point sources of nutrient which is science-based and economically and technically feasible. Has demonstrated to whom?
It can demonstrate to the department through this regulatory process. And that's the thing for here and this specific ordinance, it is the timing of it and the language. But to concede with this overall harmony aspect, there could be, sitting here today, we don't know what the water quality goal is for Naples Bay. There's an opportunity for the city to come in and provide the 800 pages that they
But
provided.
wouldn't we then as judges say, we're going to need another table that shows us X, Y, and Z, but we're just sitting here as judges instead of any expert in the field or any lawmaker who's listening to debates about this and why a certain table should reflect a certain, I don't even know, nutrient in a body of water. I mean, I don't know, right? So how could we as judges sit here and say, no, that's not comprehensive enough. I want a table that says X, Y, and Z.
Yeah, you're saying they had to demonstrate it, picking up on that, you say they had to demonstrate it to the, to the State Department. If that was the case, I would expect it to say that in 4039337, like, the local government has demonstrated as certified by the State Department.
So-
Right, it doesn't say that.
It is that the TMDL process is an administrative process. So there are administrative orders that are issued. There
But I'm
are,
saying nothing in 4039337 says that the outcome is dictated by that process. It doesn't say local governments have to get certified by that department to do this.
that is the merriment and the recognition between 4039337 and 403-067. That administrative criteria is recognized within that larger TMDL program.
You're into your rebuttal time. Any other
I
questions?
have one more question.
Go ahead.
And I don't mean to beat a dead horse here. I just want to, so in your mind, is it relevant at all whether the ordinance is trying to regulate application or formulation? Is that relevant?
It is relevant for formulation because we believe it is expressly granted. When it comes to the.
But if they follow all of the criteria in 9337, it would be fine.
So, I've tried to intentionally separate the difference between formulation and application because that's where, and I hope I'm trying to clearly get the point home here with the merriment between the two statutes. There's an opportunity for the city of Naples specifically for this process to address Naples Bay to potentially have to pass a more stringent ordinance. But I can't tell you standing here today if that is scientifically supported. And that is where.
If it was scientifically supported and they followed all of the criteria in 9337, could they regulate formula?
No, because it's expressly permitted to the state, but that's to get to the distinction between formulation and application. That more hypothetically, that if Naples Bay is determined through the DEP scientific process that urban fertilizer and non-point source is the issue, they may be able to pass an ordinance that addresses application. But we don't know that because that science and that process has not, it just started when it was deemed impaired. And we don't know what the cleanup goal is. And we don't know what if more stringent regulations, part of this larger comprehensive process that would be determined by DEP and the collective stakeholders to clean up that water body. That ordinance may exist, it's just not here today. And the city acted too early when they initiated more stringent regulations in 2019 and again in 2021.
Okay, thank you very much, council.
Thank you.
We will be in recess for a break before our last case.
All right.
Okay, our third case on the docket is 23-298 Finch Law Firm and Fromming and Finch, PA versus Massey Construction Group, Inc. et al. Yes. How much rebuttal time would you like?
Initially 10, Your Honor, but I will revise that depending on the question.
Okay. And you may proceed.
Thank you, Your Honor. Good morning, Your Honors. My name is Alex Finch. I am both a party in the trial litigation, party to the appeal, trial counsel, and appellate counsel. So I seem to wear a bunch of hats here today. Like Judge Brownlee, this is my maiden voyage in oral argument in the 6th DCA, and I hope the waters aren't too deep and turbulent, but we'll see. I had the opportunity to sit through the prior oral arguments, and the panel was keen to let the attorneys know that they had read the briefs, they were aware of the facts, and that you don't need a rendition of what's already been presented. It's the appellant's position that our brief is fairly is pretty full as to the issues, as to both the law and the facts. So I would ask if anybody in the panel has specific issues in the brief or in the appellee briefs that they would specifically like addressed rather than.
Counsel, your argument in the briefs was essentially that these were, technical violations. And it seemed more than that. I mean, it really wasn't it's not like somebody, failed to date an agreement or something. 4-1.5F2 is pretty specific. In writing, signed by client, signed by a lawyer, right? This seems like a wholesale failure to comply with the rule or even attempt to comply with it. So it seemed really odd to me to be characterizing it as a technical failure when it's, it's an important rule. It's a rule of the Florida bar. And it's not like somebody tried and missed one of the requirements. It was a wholesale failure to comply with the rule such that it essentially results in an oral contingency fee agreement. And, I read what you said about Chandris. I think your point was that, Chandris pertained to the types of agreements that are wholesale prohibited, not technical violations, but oral contingency agreements are wholesale prohibited.
Appellants agree that oral contingencies are wholesale prohibited. That's not in dispute in this appeal. We do disagree that it's a wholesale violation by the lack of the signature. First, I would point out to the court that the record evidence was that there was an agreement signed by me and that it was administratively destroyed and transferring into digital format. The trial court found that the lack of the signature on the within the four corners.
Did the firm Fromming and French send a contingency agreement to the client?
No, what we rely on in that regard is the next section of the brief, which indicates if you take the Chandris agree in writing rule, sorry, excuse me, all that is required is that there's a trail where the parties assent to the terms of that agreement. Here, the client signed the agreement, so did the attorney who lost the copy.
Hold on, the client signed it and never gave it to you. Right? I think the signed copy was found in discovery. You never got a signed copy from the client until the lawsuit happened,
No,
right?
that's not the testimony in the record. The specific testimony in the record from me is the witness was that it was signed in duplicate at the client's office. My copy went to back to my office, which is in Longwood. Their office was in Naples. It was transferred to disk and then the digital copy was destroyed.
But does
So-
any of that matter, counsel, if your firms or either one of the firms withdrawal from the cases was voluntary, does any of the rest of it matter? Is
As
that
to-
dispositive?
Yes, the existence of the agreement is dispositive of whether or not withdrawal voluntarily prohibits quantum merit. That's the Farrell versus Romani rule and its progeny. So if there's no agreement, then we're just on a straight quantum merit basis.
And that's where the voluntary nature of the withdrawal is dispositive.
Yes, as to fees, if there's an agreement. If this panel finds there's an enforceable agreement and then finds that there was voluntary, sorry, excuse me, Your Honor, a voluntary withdrawal, then there is no right under Farrell versus Romani for a quantum merit fees. The reverse is not true. If you find no agreement, then multiple cases that are cited in brief find that if there's a failure of agreement for some reason, contingency agreement, there's still the right to quantum merit fees.
So really
And that's
your,
that's Chandris, that's the O'Malley case. The Salcedo, Mineo Salcedo, the Cesar case, all stand for that proposition. And in that case, the elements that the court would apply are standard quantum merit, service provided, service received, is it just for the attorney not to be paid for it? Responding back to Judge Mize's question, there's a body of case law following Chandris that applies to Chandris other agreement in writing, the Path Medical versus now support Path Medical. There, the attorneys tried, they never got a written agreement from anybody, client or themselves, but they had emails going back and forth. And the fourth PCA said those emails were not sufficient to be the other agreement in writing because agreement. That's not the case here. One, the client signed it, acknowledged it. Two, I signed it, whether this panel or tri-court believes that testimony is another issue. Three, they operated under the terms of the agreement.
but aren't you
back and forth,
talking
even
about
as they're
whether the
firming
writing,
intent.
counsel, aren't you talking about whether the writing sets forth the essential terms of the agreement? Like an email, a subsequent email, because you don't have the contract. You don't have a contract that complies with the rule, right? So you're necessarily relying then on subsequent emails.
Yes, as to Fromming and Finch's legal relationship with, no, as to the Finch law firm. And I
Hold
bet-
on, it was undisputed, I thought. Because the rule requires, you just said you had one that complied with the rule for the Finch law firm, requires signed by client and by lawyer and a fully executed agreement provided to the client. Did that happen for the Finch law
From
firm?
my testimony at trial, the answer is yes. From the client's.
You just don't
testimony,
have it
one
though, right?
along with my signature was not able to get to the court due to the administrative errors of construction of the document. But even without that, the issue here is, does it have to be within the four corners of the agreement? Chandra says no. The Mineo Salcedo law firm case says no. Pathworth Medical says no. All of those talk about ratification, adoption, where one person has signed it. And there's just case law this high, Your Honors, that say the person signs a contract, the other person can enforce it if they perform under it and ratify and adopt the term. In this case, I'm the non-signer. I've ratified, adopted, and both parties performed. It is absolutely undisputed in this record that all parties work under the terms of that written agreement that bore Massey Construction Group signature. That's
Yeah, but,
undisputed.
yeah, but normal contracts aren't governed by the Florida Bar Rules, counsel.
Right, but they are, but contingency contracts, professional contracts are governed by rules of contract, general rules of contract.
Except as modified by the Florida bar rules.
Um,
Like the Florida bar rules impose additional requirements on lawyers that aren't imposed on normal contracting parties. Right? Like there are oral agreements that are many times enforceable, right? Provided, there's statute of frauds, but as a general rule, oral contracts and, different ways to agree to contracts. 4.15 F2 says specific requirements that lawyers have to follow that don't apply in the normal context, right? And one of those is everybody's got to sign it. And everybody participating in it must actually sign something agreeing to be bound by it.
yes, but that promulgated rule, Your Honor, of the Florida Bar has been interpreted by the Florida Supreme Court and other district courts of appeal within the state to say that you don't have to have a signature within the four corners of the document. What you have to have is agreement in writing. That can be emailed, Font versus Nelson. That can be the Mineo Salceda agreement that were there. Both people said, we have an agreement, we lost, it, we can't find it. So the court treated it as being, it wasn't given to the court because it was lost for some reason by either of those parties.
Well, that was what I was asking you about, counsel, are these subsequent emails? Do you have, what subsequent emails, what's the most that they show? Are there terms outlined in any of the subsequent emails, material terms of the contract? I know that there was some exhibits exchanged via email, is that correct?
Yes, all things were, exhibits, claim things were through email, all. But yes, there was an email in August of 2019 when Fromming and Finch was formed, which was formed as a result of the request by the client to get more attorneys because of the volume of the cases. Fromming and Finch was formed and an email was sent to Mark Massey of Massey Construction saying, a firm has been formed with another colleague to work on your cases under the same terms as before. And that's cited.
And is there an email where he responds and says, I consent to Fromming and Finch taking over this contingency fee agreement?
No, what he did after that was he started sending all claims to both Fromming and Finch.
So it says
And
no
to me.
lawyer or firm may participate in the fee without the consent of the client in writing. Each participating lawyer or law firm must sign a contract with the client. So we got Fromming and Finch.
In another writing, that's the Chandris ruling and the other ruling has been brought forward.
That's not what the rule says. I mean, I stopped, I didn't leave anything out. That's the whole.
I understand that, Your Honor, but
language.
that's not how it's been interpreted by the courts. And this court's very pointed in its decision that it doesn't have to follow other district courts of appeal, but it does have to follow the Florida Supreme Court. And Chandra says in that rule that it can be an agreement in writing other than the contract, and that's what we have here. Did he agree? Did they agree? I'm not aware of a responsive email back saying yes. He met with Mr. Fromming, approved his services, and then accepted his services in over 400 cases, approximately 400 cases, over a period of 2 years.
Yeah, but I mean. Lawyers and clients take on representations. I mean, under the Florida bar rules, you don't have to have a written engagement letter unless it's contingency fee, right? So you can have an oral agreement with your lawyer. So the fact that he worked with the firm doesn't tell us much. 4.15 F2 says for contingency fee agreements, right? No lawyer or firm may participate in the fee without the consent of the client in writing. Doesn't consent, it's not the client consenting to representation, it's the client consenting to the law firm participating in the fee. And each participating lawyer or law firm must sign the contract. I understand your argument about Chandris pertaining to technical requirements. I think these go beyond the technical requirements. And Chandris is pretty clear, a contract that fails to adhere to these requirements is against public policy and is not enforceable.
And it's equally as clear, it said that the requirements of that rule can be met in another writing, in another agreement in writing. And that's what the email.
Well, hold on, Chandris predated the current version of this rule, so they couldn't have been referring to this rule.
No, well, in Smith versus Bernetti, a second DCA case, Justice Sasso and the dissent indicated that the Chandis rule was brought forward into the new Florida bar rule. That ruling was brought forward as applicable to the new bar rule.
Yeah, and
So-
I think her dissent pertained to technical. And obviously she was in the dissent, right? The majority found that Chandris was binding. And she distinguished Chandris by saying that, you know, in the second DCA case, these pertain to mere technical requirements as opposed to Chandris, which, you know, pertain to wholesale failures to comply.
Actually, I disagree, Your Honor. Chandis applied to a firm bringing in an unlicensed attorney to participate in the fee. That's a wholesale failure. We can't have.
So are oral contingency fee agreements.
Yeah, and this is an oral, it's in writing, it's signed by the client, and it's agreed to, adopted and ratified through performance, and it was agreed to in writing by the attorney.
Let me ask you this.
We didn't, excuse me a second, Your Honor, we didn't need another, Finch Law Firm didn't need another signing from Mr. Massey. It was my signing that was in question, and I sent the email. Secondly, it's a Fromming and Finch. Fromming and Finch was formed with Mr. Fromming as a lawyer under my supervision for my client. That was the Massey Construction Group was made aware of that and agreed to that, performed under that, and then made no issues about that until charging claims arose at the end of the record.
Let me ask you a question, counsel. So,
Your Honor.
you, outside of the contingency fee context, you don't have to have a written agreement, right? And when lawyers and clients enter into representation without agreement, it's typically the lawyer can sue for market rate, right? I mean,
For
it's-
quantum merit.
yeah, for
Yes, sir.
quantum merit, yeah, which is not calculated on a contingency, right?
No, Your Honor.
So if a client just starts working with a lawyer, that can form an agreement, right? But it wouldn't be a contingency agreement.
Sure.
So you're saying that, hey, the client worked with the firm here. So even though the firm didn't sign the agreement, and even though the client didn't sign anything consenting to the firm participating, take that as basically implied consent. The problem is, when a client engages an attorney without an agreement, the implied consent can be to lots of things, and the typical default is not contingency, right? It's quantum merit. So why would we take implied consent as implied, you know, to when a client engages a lawyer as implied consent to a contingency fee agreement? When normal implied consent doesn't imply contingency fee, and the contingency fee rule prohibits implied consent.
Two responses, Your Honor. One, this is not a pure contingency agreement. It has 4 levels of compensation for the attorney, only one of which is contingency. The other 3 are statutory fees awarded by a court. Insurance, voluntary payments by insurance companies, apart from the contingency. And in this case, as those fees were paid, the amount of the contingency reduced till it was eviscerated. So it's not a pure contingency agreement. Second, I would disagree with the court's characterization that it's implied consent. The agreement and other writing and the law that's provided that applies to contracts that are attorney fee contracts based on cases cited in the brief. Performing and sending the documents, applying the contingency fee are all ratification and it's not implied, it's expressed. It's expressed through the conduct and representing the party. I'd like to yield the take the remainder of my time for rebuttal, unless the court has other questions that it wants to ask, and we'll rebuttal.
Thank you.
Thank you.
May it please the court. Good morning. My name is Mike Fink. I represent Massey Construction Group Incorporated. Let me start by saying absolutely there is no difference with regard to the outcome in this case, whether or not there is a valid written contingency agreement or whether there's an invalid contingency agreement. I wasn't clear on that. I believe I've, in this case, heard that argument being made that under this circumstance, we could still get a fee, but that is not the case under any of the cases, and there are numerous cases that have involved valid contracts, Capina, I think, Faro, I think many, Cali, I believe.
Because of the voluntary termination, the voluntary withdrawal council.
That is absolutely correct. Now, this particular agreement that, let me back up and say this. The purported written contingent fee agreement that was placed into evidence in the trial of this case was an agreement that that was disclosed or came about after several months when the client contacted ethics counsel and sent the file to them. When I realized that what I'm looking at was not an actual agreement that was signed and delivered, and we had the original, I went and said, let's get the whole thing. Let's look at it carefully. There was no agreement in the file that had Mr. Finch's signature. This is related to Finch Law Firm before Froman and Finch is created, middle to end of July. In August, beginning in August 1st, August of 2019, every case was handled solely by Froman and Finch. Now, it was and still is a pure contingency fee agreement. The provisions that relate to the insurance company paying the fee still, they're all contingent
On victory, on recovery.
on recovery. There is, to be totally fair, an unclear provision about paying $1,500, about paying initially for a demand. That was conceded that was never applied by Mr. Finch during trial. He admitted it's a pure contingent fee agreement. And that's important because it's got to be, from my perspective, certainly from Massey's perspective, a contingent fee agreement. And while you can't ethically have a oral, verbal contingency fee agreement that you can enforce, the fact that you attempted to enter in one or claim you entered into one that either did not comply with Rule 4-1.5 or some other rule, or wasn't signed or whatever, doesn't change the fact that it was contingent. The issue then is under Rosenberg that you can't get a benefit by not having a valid contingent fee agreement. And that's what I believe I was hearing in the discussion by Mr. Finch, is that, oh, if there's no agreement, you get quantum merit fees, is what I would count. That's not true because of the withdrawal. That won't change that issue, because you would be, Rosenberg, if I'm correct, stands for the proposition that you can't benefit. So you can't benefit by not having a valid contract or by violating an ethics rule. So if you put 10% in your invalid agreement, written agreement, obviously in this case, they agreed verbally, hey, it's 10%. That's how that was one of the sales pitches, which was in evidence in this case, that Mr. Finch said, hey, it's going to be 10%. That's why they entered into the relationship, is for the 10% contingent fee agreement. So Rosenberg says, whether it's invalid or not, well, even if it's invalid, you still don't get more than 10%. Your quantum merit will be limited to that. Well, that's not applicable in this case because of the withdrawal and because of the failure of the charging lien attorneys to meet their burden of proof under the Faro v. Romani case, which we take the position, and I'm extremely confident in the fact that that's the correct rule. There is no backup position or backup rule that as Mr. Finch has outlined in numerous pleadings and in his brief, that, well, if you have good cause to withdraw, because in Florida, it's a voluntary representation state, and the court in the cases cited by Mr. Finch, Fisher, and Elton made clear that unless the case is set for trial, or it's going to cause some disruption of the administration of justice, normally if it's already set for trial and the court's well down that path, the Client is free to terminate the lawyer at any time. The lawyer is free to terminate the client. The question of whether or not the attorney receives compensation following that termination is one of a thorough analysis, and that is, and I've never seen anything in this case that in any way, in my opinion, on behalf of my client, Massey Construction Group, Inc., that indicated that Massey Construction Group did something or acted in a way that was so horrible that compelled Fromain and Finch to withdraw. That is, nothing Massey Construction Group Inc. did caused the continued representation by Fromain and Finch to be impossible, which Mr. Finch stipulated in the beginning of the trial in this case, leaving only or that the continued representation would violate a bar rule. And I would submit to the court that this concept that a violation of a bar rule, a conflict under Rule 4-1.7, the lawyer's financial involvement as a result of the contingent fee relationship does not create that right to say, oh, I feel this way or that way, or I'm involved, when the reality is we represent clients and the clients come first. Their interests come first. And when you have 250 cases and a client sends you an email on a Friday and you, without speaking to the client, having any further conversation about that email, terminate the relationship on a Sunday.
But counsel, can I ask you about these emails? In the April 30th email, is there any doubt in your mind that at least some of the 250 cases would be transferred? So let's see, the RCV offers, the current RCV offers, right, that are referenced in that April 30th email, that those were going to be transferred to another law firm, thereby terminating representation with the existing firm?
No, Your Honor, that's not true.
Okay, can you help me
And,
with?
and what I believe in the testimony, we clarified that because what the charging attorneys tried to say is, oh, see, this means everything. And isn't that true, Mr. Fromain? And it's 90% of the cases. No, that's not. They were, it was.
But it was
it
to
was
some of them, right?
They talked
no?
about, they had a handful before 2021. And then there was a couple that were so late and nothing had been done on them, but they had that were, and I
The current RCV offers.
yeah, the current RCV offers, they were saying, you know, move these cases along, go back and attempt settlement.
It says settle these by Friday, May 7th, or they will be transferred.
That's right.
So then the termination, the withdrawals from Fromain and Finch came before May 7th, correct?
That's correct. May 2nd. Well, they have it. Fromain and Finch took the position that as of April 30th, 2021, the date of Mr. Massey's email at 10 or so in the morning, 10:34 or something in the morning on that Friday was the termination. And
Counsel, we have 26 cases pending in the 6th DCA, which I assume are the ones that came up from the 20th Circuit. The record indicated that there were 250 cases statewide. What's the status of the other 224 cases? Are they still in trial courts? Are they still on an appeal? Are they before the other DCAs? And out of these RCV cases referred to in that line, do we know how many of them, if any, are pending with us?
Let me attempt to answer your question as best I can. All of the pending cases, wherever situated on the East Coast, West Coast, from Tampa to Naples, with regard to Massey Construction and Fromain and Finch, are awaiting this court's determination. We have filed in each of those cases that were not part of the 26 in front of Judge McHugh, motions in all those cases based on collateral estoppel and res judicata.
Have any of the trial courts ruled?
No,
Are all those cases stayed?
not formally, but they are. Nothing is
Both
going
parties
on.
are just kind of waiting.
That's right.
Out of the RCV cases, do we know
if any of those, the third bullet point of April 30th email that our current RCV offers to opposing counsel have by next Friday, May 7th to settle, or otherwise will be transferred. Are any of those within R 26?
I couldn't tell you, Your Honor. I know that those were approximately, I want to say 13 or 15 cases that they were attempting to get settled. And I know that a handful of those were actually settled even, right away.
Is there something in the record that tells us how many of those two, I know you said 13 or 14, but is that in the record, how many of those 250 were RCV cases?
Maybe not specifically, but very close. There's testimony about it being a handful and that some of those were, the record's going to show you that clearly when it's just two attorneys, they sometimes had an associate, but they were running their own law firms separately and apart from Fromain and Finch. They've still got their other two firms, they're separate firms. So what Mr. Massey was concerned, when they did do work, when they moved those files, they could move them. They could move the files. It was just an issue of, they really didn't have enough hope. They didn't create a machine to handle all the cases, and were, as far as my client's concerned, were fine dragging them out.
Your client wasn't happy with the representation. They made a threat to fire them. But you're saying we didn't actually fire them, and they say they did fire us. You say it was a threat, they say it was a firing, right?
Well, but they'd had issues like that before, and they.
I know that's your argument. I'm just saying, you say it was a threat to fire, they say it was a firing, right? This comes down to what the April 30th email says in terms of who's right.
Yeah, what they said and what reality was, right.
If I'm correctly characterizing it, don't avoid saying it.
Well,
Seems
you
like it
correctly,
comes down to the April 30th email. You say it was a threat, they say it was a firing, and we got to look at the email ourselves, right?
the communications reflect what you're saying. Perhaps not reality, because if you're running a business and you've got all your eggs in one basket and 250 homeowners want their new roofs. And
You're saying they made a threat, but it might have been a bluff. That in order to.
That's what I'm
fire
saying.
their attorney?
well, that's exactly what I'm saying, is that he wanted to have a meeting, to get together, which should have happened. I don't want to go into personalities and all that, but we have a duty as attorneys to recognize the client's the boss, and the client, you have to communicate. It's like the attorney's fee contract, you have a duty to explain these contingent fee agreements. And one of the reasons why, the new rule, and I agree that Chandris didn't directly, Chandris brought into effect the new rule, but did not proceed further to evaluate how it would apply in every situation such as this. You really need to have a sit down where you explain to the client, here is the agreement in a setting, here's what these provisions mean. It really would not be appropriate to use other emails without a very significant substantive communication related to that agreement. It should be, I'm just going on record saying that it's really important for clients to understand the relationship, how fees are going to be charged, whether 10% is real or not, which is important in this case, but for another day.
The May 2nd letter is obviously much more detailed than the April 30th email. I guess with purported reasons for termination and things like that. Was there ever any written communication from your client confirming anything that was in this May 2nd letter?
No, Your Honor. They had one or two phone calls between. I was never 100% clear on what communications were had. I believe Mr. Fromain had a few communications on that Friday. I'm not aware of any communications happening on Saturday and Sunday, except for one on, I believe, Saturday, transmitting, Mr. Finch is working on Saturday, transmitting a memo related to whether they go into arbitration or whether they go into appraisals. I should say appraisals versus filing the suits and so forth. But then on Sunday, he terminates and begins filing the motions to withdraw and canceling all events set forth in those 250 cases. Suffice to say that from our perspective, looking at, if you just objectively looked at the email from client of April 30th, 2021, and then the 9-page formal termination letter from Mr. Finch on Sunday, the 2nd, 2021. I believe probably now, like midday or 1:30, something like that. That it's evident to us, at least we argue that they weren't even clear whether they had any conflict. They were trying to do everything they could to put what we call a square peg in a round hole and say, oh, it's your fault. You know, we're saying that this thing you did constitutes termination. And therefore, then they start talking about whether there's a conflict or not. And they don't really say that. They say, we don't know yet, but they immediately begin, they immediately terminate. So we were not able to establish, or I've never been able to appreciate or understand what the conflict, what the continued representation issue would have been, because Mr. Fromain did all the communications. Mr. Finch was not involved in negotiating resolving the cases. He was involved in drafting meetings and so forth. So it was my understanding that all the communications and what the client wanted was being communicated to a person who understood, who was able to get things done. We did not believe, Massey did not believe he was terminating them. He certainly didn't plan on terminating them. He was not in a position to terminate them. He had nobody standing by. It was a total, absolute train wreck. And it affected significantly, the status of cases and the administration of those cases in Lee County and other counties as well, primarily Lee and Collier. But suffice to say that it was news to them that it was being interpreted as a termination, and that they somehow had terminated when all they were trying to communicate is, look, we need to move these cases. Here's what we need done. Here's what we want to do. That really should have been resolved, could have been resolved, just like it had been in the past. But doesn't change the fact that their determination, their decision was a voluntary one, and any possible conflict or any possible evidence that would support an involuntary withdrawal was created by the attorneys themselves. And that is, that cannot be the basis of an involuntary withdrawal if you create the conflict in the issue. If it's your feelings and you feel like you can't work for a client because of your feelings, or because you want to control and you don't want the client to take more control and you're used to being completely in control, I get it. But that's what we do for a living, is put the client first and work things out just like you would in any other relationship. The fact that this involves so many cases only exacerbates or makes the issue more important, and the duties of an attorney to work through issues and disputes and come to, come to understandings and communicate with the client, imperative. We believe the court's final judgment entered in this case should be affirmed. The issue of whether there's a contract, they don't have a written contract of any kind with either firm. There was never even an attempt with regard to Fromain and Finch PA that was created. There's no exhibit A to the first contract with Mr. Finch's DBA Finch Law Firm. There's not anything that would suffice. I mean, you would think that before you were, no, never mind, on that Sunday, to withdraw voluntarily from that many cases and not, or to start a new firm without making sure you have contracts in place. Lots of I'm not going to go into all the mistakes, but it was not clear at all whether, the court found there was no agreement. And Mr. Finch said he had a standard of making 2 originals, but then he destroys his original, leaves it with the client. I never understood how that worked. Made no sense to me. But bottom line was, there are no fully executed CCP agreements in compliance with 4-1.5. It's not really relevant since the withdrawal
Time
by
council.
them is voluntary. Thank you.
Your honors. I'd like to address just two issues. First, the questions that you had, Judge Myers, on the status of cases. All of the cases in front of Judge McHugh or RCV cases. In fact, RCV just means that there's an offer out from the client to settle their indemnity claim. And the testimony at trial and contradicted was 99% of the claims with our firm were RCV claims. So in saying settle them within that period of time, that was all the cases within that 10-day period. Secondly, of all the other 250 cases, Your Honor, they've all been dismissed except for a handful. The 26 before this court, a few cases that involve settlements prior to termination of the services, but there are not 200 cases spread about this state on charging liens.
Are there other cases where the same issue, the parties are in the same dispute?
I'm sorry, I don't understand.
Are there other cases other than these 26 before us where the parties are in the same dispute?
Yes.
Confirm one.
All of them involve the same dispute, all of them involve the same parties.
How many of those cases are there besides our 26?
Including the 26, probably about 40 to 50, but not involving charging liens, some of them are enforcement.
Council, look at this April 30th email. Which language would you point us to as this is the termination language?
Thank you. The language in it said we will not go to trial with you. We're a trial law firm. They said they would not go to trial, engage in litigation. You are all former trial judges. The attorneys that are going to try the case are the ones who have to appear at pre-trials and things of that nature. We weren't able to do our job if we couldn't go to trial the client. Two, the appraisal issue. There's been one particularly large case, multi-million-dollar case, they wanted shoved into appraisal, but it was 2 years old litigation and the case law says you're not going to get there.
Your
If you
time's
wait-
up, counsel, so can you just wrap up your thought?
Yeah, so you're not able to do it. So all the timing within these cases and deadlines were all completely out of the control of the law firm. We couldn't compel settlements by a date certain. We couldn't compel a appraisal. So it was a constructive termination saying, if you don't get these, we're going to fire. We didn't have the ability to get these. We request that you reverse the trial court, send it back for further proceedings, finding that the agreement is enforceable, that the termination was involuntary or for permissive good cause under the Florida bar rule, and that the attorney is entitled to proceed with quantum merit action. Thank you for your time.
Thank you.
Thank you, counsel. We'll be in recess.